And I'm with the Family Law Pathways Network, Greater Melbourne, and I'm just here to facilitate things because this is an at-last forum, despite its title, because we have finally got Louise with us. You were extraordinarily interested in this forum when we first tried to advertise, well, we first advertised it, and unfortunately Professor Newman had some circumstances that made it impossible to proceed, but here we have her. I'm just going to let you know that Louise Newman is the Director of the Centre for Women's Mental Health at the Royal Women's Hospital and Professor of Psychiatry at the University of Melbourne. Prior to this appointment, she was the Professor of Developmental Psychiatry and Director of the Monash University Centre for Developmental Psychiatry and Psychology. She was the founding chair of Perinatal and Infant Psychiatry at the University of New South Wales and the previous Director of the New South Wales Institute of Psychiatry. Goodness. In January 2011, she was appointed as a member of the Order of Australia for work in child protection. She is a practising infant psychiatrist with expertise in the area of disorders of early parenting and attachment difficulties in infants. She has undertaken research into these issues, into the issues confronting parents with histories of early trauma and neglect. Her current research focuses on the evaluation of infant parent interventions in high-risk populations, the concept of parental reflective functioning in mothers with borderline personality disorder, and the neurobiology of parenting disturbance. She has published in a number of areas as well and is co-author of the textbooks Clinical Skills in Infant Mental Health and Contemporary Approaches in Child and Adolescent Mental Health. So we will have also some representation from the bench. Judge Curtin, who's come from a busy duty list where things such as what we're going to hear from Professor Newman are all too common in the presenting issues, I'm sure. And we also have Sergeant Natasha Powles, the Family Violence Advisor for North West Metro Division 1, which covers the LGA's local government areas of the City of Melbourne and City of Yarra. That police violence advisor, there's one in each region in Victoria, and they're responsible for consultation with community agencies, identifying and reporting on local issues and trends in their region and developing strategies to address them. In addition, Natasha has joined the committee of the Family Law Pathways Network, and it's a long-sought connection for the network with the Victoria Police. So let us start by asking Professor Newman to come up.
Thank you very much, and thank you for inviting me back. It feels like resurrection, I think, in this time of year. It's important to reflect on these issues, but I'm very pleased to finally be here to talk about the really complex issues about mental illness in parents and the implications for children. And obviously these are issues that people here are all too familiar with. So in many ways, what I'm going to describe to you is maybe a focus on the implications of parental mental illness and mental disorder, as opposed to going through in great detail what we do know about every single mental disorder. And maybe, I can be a bit disparaging about psychiatry, but actually we don't know everything about all mental disorders. What we do know, and what I'll hopefully be able to talk about, are some of the issues of risk and how we might think about evaluating risk, which is an issue obviously in your work that comes up repeatedly. How do you actually think about the impact of whatever the diagnosis might be on children and children's development and safety? And are there potentially some mental disorders or conditions that are likely to have greater impact on children? So I'll address those in broad terms, and hopefully we can have some discussion about that. What I won't be able to do, and I probably shouldn't apologise for it, but I will not be able to tell you how to fix the mental health system. As you're aware, the mental health system is particularly stressed, having great difficulties dealing with, I guess, the volume of people who need services, who find it sometimes very difficult to access care and services, and increasingly acute presentations, largely drug-related issues, which we're all grappling with in our various areas at the moment. So we are in the middle of a very difficult time. And in these sort of times of limited resources, there are some groups who are maybe even less well responded to. Children and adolescents and the needs of families have never been well responded to relatively within the system. If we just look at funding, we look at dollars. So there's a huge amount of unmet need. That continues despite the fact that we've recently had, as you might be aware, release of what is being described as a review and a revolutionary way of looking at mental health services. Unfortunately, it doesn't seem to cover children or families in a direct way. We certainly are seeing the complexity of social pressures and social factors that influence people's mental health. And maybe that's a factor that we need to take into account when we think about the impact of the diagnosis. People with mental illness and mental disorder are much more likely to experience a whole range of social adversities, and this will particularly impact their parenting capacity. So we know roughly that around about 1 in 4 or so children and young people, that's starting in infancy right up to adolescence, have parents with some sort of mental illness or mental disorder. So the numbers are obviously quite significant, but we also know that not all of these children and young people are going to necessarily have easily defined negative impacts. We know, however, that the issues confronting those parents are the issues that are also going to impact their children: poverty, social exclusion, discrimination, homelessness, the whole range of negative factors that make it very hard for people to provide for children and increase stress and anxiety within any family system. Those are the factors, as opposed to the diagnosis, that are more likely to impact on family functioning and child welfare. So overall, of course, parents with mental illness are more likely to have their children placed in care, whether that's respite care, brief periods, alternate care, or actually permanent and ongoing placement. So that's well established, but the factors underlying that are really quite complex. So I thought maybe one way to think about this is to try and, as I said, not focus so much on the diagnosis, but focus on what we think of as parenting capacity, because in many ways within a legal framework and within a mental health framework, regardless of the parent's diagnosis, we're trying to evaluate their capacity to provide sustained emotional care that promotes healthy child development. So we're looking at how do we better evaluate parenting capacity. We do know, and we've known this since the 1950s, when Rutter, a very well-known child psychiatrist, looked at parents who had a diagnosis of schizophrenia and compared them to parents with a diagnosis of severe personality disorder, which is something I will talk a little bit about today, that if that severe mental disorder, schizophrenia, was well managed, and we've got much better ways of managing that condition now than we did in the 1950s, then children were remarkably resilient in the face of having a parent with an episodic illness. In other words, people can have schizophrenia, bipolar disorder, common enough conditions, and they're not affected on a daily basis by that condition. They might have episodes of illness, they might even have hospitalisations, which can certainly be a stress for children. But children, if supported adequately, so they're in a good enough social environment, can actually manage that condition relatively well. Personality disorders, and we can define these as we go along, but difficulties that people have in interpersonal functioning and in managing themselves every day. And in the face of that, children are much more likely to have a whole range of negative experiences. So from that perspective, what we're trying to think about is the child's net experience of their parents' emotional availability. So what we call parenting capacity in the positive sense is really based on that parent's empathic understanding of their children's needs. So even in the face of having an illness or having stress or social difficulties, does the parent still have that ability to think about their child? And when we see deficits in this, it's really quite noticeable. So we might say to a parent, how do you think your child feels? How's your child going in the face of they've been exposed to this particular stress, or they've been separated from you? And some of the parents that we're working with might not be able to really think about that at all. They might deny, even at one extreme, that the conditions have got any impact on the child at all. Or they might be insensitive to the needs of the child. They might not recognise that their child is anxious or frightened by the circumstances at home, or by the fact that the parent at times is disordered. So there's a range there, but that level of empathic understanding of the child's position is actually a very important factor, and helps us evaluate that issue of risk. We also need to see parents who hopefully have the ability, even in the face of illness, to act as attachment figures, by which I mean being available, being consistent, being able to understand that the role of the attachment figure, as we talk about it in psychological terms, is to be available for the child and to act as a secure base. So that means that the parent needs to be able to accept that role and see that as an important function. So they might understand that if a child's frightened or if something stressful has happened, then they're the one, as the responsible adult, as the attachment figure, who needs to be able to provide comfort and reassurance and security. And you'll have come across many examples, no doubt, where a parent really doesn't do that, or they do it in a very inconsistent way, or occasionally they might even resent that. They might not want to focus on that. They resent the child's neediness or the child's dependency. And particularly some of the adolescent parents that I would see, very high-risk young women who come from backgrounds really of neglect and trauma themselves, find themselves with a young baby who they, on one level, are very connected to and devoted to, but on the other hand, they're very resentful if the baby interferes with their social lives and other things that they really like to be getting on with as adolescents. So they resent the child. They're not very good at understanding the role as an attachment figure. So that involves consistency. So many of the children we see who are quite traumatised by their parents are children who become very confused and perplexed about the availability of their parent. Will my parent be nice to me today, when the parent's behaviour is sometimes quite difficult to predict? So the parent occasionally might be a very adequate and responsive parent. On other occasions they might be neglecting, ignore the child. Other occasions they can be angry or even hostile. Children are cognitive beings, and even very young children try and predict the behaviour of their caretakers. They try and work out and predict ahead. How should I behave in the face of this when my parent's rather confusing? And if they can't come to some understanding of that, or if it doesn't work, if the behaviour is literally unpredictable, then those children become frightened, confused, and what we call very insecure from an attachment point of view. That's very common in the children that we see through systems where we're seeing families in crisis or families undergoing difficulties or separations. There's often a breakdown of that caring function and a breakdown of the attachment function. Parents enmeshed in their own conflicts often, or their own difficulties, seemingly lack that focus on the needs of the child. So the child remains what we think of as being in a state of high levels of stress and anxiety. And from a developmental point of view, those high levels of stress are likely to have ongoing consequences for children's health and development. there's a whole lot of biological research which I won't labour, but just to be aware, and people can read this and follow it if it's of interest, that a lot of the evidence is actually about stress-related hormones, so things like cortisol, adrenaline, the hormonal responses that frightened children have, and the impact of that on brain development. So these are long-lasting effects. So a lot of the psychological literature and mental health literature will talk about trauma in the early years as being very significant, not only from a psychological point of view, but in terms of brain development. So some of the most severely impacted children that we see are those who have literal difficulties in neurodevelopment and brain functioning. So they might end up with lots of different diagnoses, which makes the job of interpreting reports obviously incredibly difficult unless your report writers are very clear and weigh up for you the issues of differential diagnosis. But these children can end up with multiple diagnoses and different diagnoses depending on the type of clinician that they see. So you'll be familiar with the common ones. All these children can be diagnosed as having attention deficit hyperactivity disorder. In fact, that applies to any child that moves. They can be diagnosed as having anxiety, which they probably do. We can look at their behaviours and say they frequently have oppositional behaviour or even conduct disorder. Again, their behaviour is often very dysregulated. Some people will use the diagnosis of attachment disorders to talk about it more broadly, which I actually think is a more useful way of thinking about it. But the difficulty is that we end up with a very perplexing report for us as readers that might use lots of diagnostic categories, but not necessarily give us the picture that we need in a decision-making context to think about why the child is so dysregulated. Is it a genetic problem of the child? Does the child have an organic brain difficulty? How much of it is environmental? And then, if that's the case, what are the stressors that are contributing to this child's developmental difficulties and their psychological problems? Because in a sense, we have to come up with some sort of judgment if we can, if we know the risk factors about what sort of intervention a particular family or parent might be able to be engaged in. I say might with a bit of hesitancy because we also are aware that not all of the families that we're seeing are going to either be accepting or able to use the sorts of psychological interventions that are available, if we're lucky to be able to access them. And children do not have the time to wait whilst we might do long-term psychological interventions with parents or carers, which is always a dilemma. We know about the significance of the first 3-4 years of life in terms of children's long-term outcome. That's the period of life when our brains are growing at their most rapid rate, so it's extremely significant. And we know that breakdown of care during those critical early developmental periods are likely to have significant long-term implications. Decision making, and I'm, I think, somewhat relieved that I merely make recommendations and offer an opinion, which is very different, obviously, to having to make the decisions. I think decision making in that context is hard because we are also looking at options that we have for alternate care of children, whether that's in the family or kinship care or in alternate care systems. And getting that balance right between connectedness to family origins and culture in some cases and protection of the developing brain is very difficult, and I absolutely acknowledge that. But from the basis of the science, if we're going to make decisions about alternate care, doing it to summarise, earlier rather than later, trying to avoid, as we will do as much as possible, some of the decision making that goes on largely and obviously in children's court and in child protection, but the issues of multiple placements of children, multiple failed placements, repeated breakdown of care, repeated separations and failed attempts at reunions with families of origin or parents is something that we should all be working to avoid. So some at the far end of the spectrum, I think, and really not the group that we're so troubled by because decision making is maybe easier. We have people who can't adequately care for their children. That might be a breakdown of the capacity for instrumental care, profound neglect. Those sorts of situations most of us come across, hopefully not frequently, and decision making is maybe clearer. But the majority of cases that we struggle with, there's some capacity at some times in an inconsistent way to provide care for the child and to think about the child's emotional needs, but it's not necessarily sustained. We might also see a breakdown of the capacity of parents to change their ideas about their child according to children's changing developmental needs and developmental stages. So the parent essentially who needs the child there for them, as opposed to seeing themselves as the parent who's there for the child. And some of the parents who, and I think we could all tell tales of really cases like this throughout the work, particularly in family court. I've certainly seen parents who repeatedly demonstrate that the issue for them is not the needs of the child, it's what the child manages to do for them. Their expectations about the child, which are totally negative in terms of what the child's actual emotional and psychological needs are. So we might think of some of our needy parents who might have gone through a marital breakdown or difficulties in a relationship, who see the child as fulfilling almost a pseudo-partner role. We see what we call parentification, so where the child acts as a carer for the parent, and that's certainly the case when a parent might be vulnerable or experiencing something like depression or other mental illness. And I'll give a little brief example of a family that I saw recently, a single mother who has quite a severe mental illness, a bipolar disorder, and had a lot of hospitalisations, and she was pregnant, she wasn't really sure how that had happened, but it was clearly the case. She didn't know, she couldn't tell me anything about who the partner was, and so it wasn't a partner, it was a transient sort of relationship of some sort. No one was around, she was unsupported. She couldn't tell me much about the father of her 6-year-old who she brought with her to the appointment. And the striking thing was that sadly her illness was quite chronic and severe. She was engaged in treatment, but she had ongoing difficulties. But the striking thing was the child, who walked in a very formally dressed way for a 6-year-old child, a very polite little boy who shook my hand and looked at me squarely in the face and said, "We're here for our antenatal appointment." Okay? And so immediately I'm thinking, you know, this child is cast in a role that he cannot possibly and should not have to be involved in. He could tell me, and he had lists in his pockets, she pulled out all his mother's medications, including side effects that she'd experienced in the past with medication. And he said, and if there's a crisis, he said, if there's a psychiatric emergency, I call this number. So he was a little 6-year-old, 6 going on 36, shall we say, with very little other support around him, who'd been missing time from school because he was worried about his mother's pregnancy and her mental state, and he needed to care for her. That was one of the examples in my work that stayed obviously in my mind. So what did we think was important for him? Clearly was to give him a break, if you like, some respite from his caring duties, and to allow him to have an opportunity to learn more about her mental illness, to make sure she had external help. The mother was very insightless. She didn't really see that as a difficulty. She loved the child. She thought he was doing, a very kind thing for her. She had no idea of the implications of that for a child of that age. So it was in no sense an abusive situation in any way that we might use the term. But the damage for that child was going to be significant. And there were programs obviously for children in that situation. He was enrolled in a program. He had some respite care, camps, and ongoing counselling around the nature of mental illness and what he should be able to do and what he shouldn't have to do, allowing him to a certain extent to give up the burden. But he was already parentified in an absolutely classical way. So these can be quite significant for children. So the other thing, of course, about severe mental illness, schizophrenia, schizoaffective disorder, bipolar disorder, those sorts of psychotic conditions, which can be very severe, if episodic, is that they obviously can result in disrupted care of children. The child who is separated because of parents in and out of psychiatric hospital. And I should say it's only relatively recently, over the last 10 years or so, that mental health assessments routinely asked, do you have children? And if so, where are they and who's taking care of them? It was always a great source of concern to me that in New South Wales, so I was running mental health services there, we asked about animals before we asked about children. Now, I'm not saying that animals don't need care as well, but it was rather ironic that on the intake forms, do you have a dog at home or a cat, and if so, who's feeding them? Not might there be a child left at home and so on. So sometimes these things have forgotten. But the issues about separation, multiple separations that these children can experience are very significant. Children become anxious, they can become distressed. They're often placed with numerous alternate carers, whether it's family or non-family. Sometimes what's very important is that children get an adequate explanation in terms that they can understand at their age about what's happening to their parent. And I think we've shied away from that. Sometimes people feel they're not sure how to do that, how best to explain to a young child what severe mental illness might be. So the little boy that I saw really hadn't had an explanation about why his mother was sometimes very disinhibited, difficult to understand, staying up all night, and he needed to understand more about that. Very high-risk, rare scenarios that I'll only briefly mention that you might occasionally hear about is where a parent might have delusions or fixed false beliefs, and sometimes they could involve a child. So a parent, for example, who might have paranoid thoughts that people are out to harm them or get them, might engage the child in those ideas, and the young child sometimes doesn't have the ability to understand that, to do a reality check on that, if you like, so they can identify with that. Unusual but very serious when that happens. Very rarely, of course, we see psychotic people who believe that their child is a persecutor of them. So occasionally in the hospital where I work, where we're seeing situations acutely after delivery, we might sometimes see what's called a puerperal psychosis, very high risk, and occasionally we've all come across cases of psychotic women who are either committing infanticide or homicide. Fortunately rare, but again, just something to note. Overall, even if we're talking about severe mental illness, children's outcome is very much related to how best we support them in the face of the illness. So the best predictive factors are going to be how well we can support the child, what sort of emotional support do we provide a child, what sort of explanation are they given about the mental health issues, and can we help them still have a sense of attachment security. So the child who knows that their parent might be in hospital for a period of time or be having these home visiting mental health support and might not be as available as they usually are for periods of time, can usually tolerate that. And we often look then at alternate carers to make sure that they get that sort of support. Most mental disorders, of course, are not psychosis, and the majority of issues that we're dealing with in mental health systems are going to be about what we call the more common, high prevalence conditions and personality disorder. In my experience, what you're often seeing in family court and other legal situations are going to be a combination of depression, anxiety and severe personality difficulty, so interpersonal functioning. So, and that's much more difficult to manage in terms of understanding the impacts on children. But depression, that's a bit uncomplicated depression, which can be severe, and particularly if we're looking at early onset depression, so what we call postnatal depression, can have a significant impact on parenting and is quite significant. Those children are much more likely to be insecure children, so to be worried about the availability of their carer. They're likely to have developmental difficulties, and if we follow them in the long term, they're more likely to develop depressive illness themselves. So there's quite clear research looking at the long-term impacts of having depressed parents. Now, some of that might be a genetic vulnerability, so the child inherits genetic vulnerability to depression. A lot of it is due to breakdown of early relating. So the depressed parent finds it much harder to be emotionally available. They might try very hard, but it's hard for them to be focused and sustained in their emotional connection. They might feel they have no energy, they're too sad, and so on. So that can be a major issue in terms of the relationship. They're also more likely, of course, to be highly stressed in that situation, to have a negative view of their child, to say, well, my child is difficult, I'm not coping, and at times they can be quite overwhelmed. So when you get at that history of significant early depression, I think the best way of thinking about that is that that child is a vulnerable child by definition, particularly if that's been ongoing. The issue of personality disorder, I think, is an important one to mention, given that within our systems we're frequently seeing people who engage with the legal system or the health system looking, if we want to see it this way, for solutions to complex interpersonal difficulties, but seemingly don't make use of the system in the appropriate way. And I think, particularly in family court, in my experience, we often see warring parties, if you like, who see the court as the arena for the carrying on of their battles. I think many of us have been involved in cases. My record, I'm sure yours are greater. 12 years of appearances before the family court. So following children who are in their infancy right through to their adolescence. I had one small boy who said, I asked him what he did he go to school, what did he do most days, and he said, I go to the family court, which he didn't actually go, but he was telling me that his perception was that that's his identity. In the middle of this warring battle between fairly difficult parents. And I think the great difficulty, we all are aware of that, but the great difficulty is to try and understand the motivation of the parties. The motivation, and why we all struggle, I think, is not to resolve their issues. In fact, that's the last thing that many of these people want. The motivation is to continue the battle, maybe unto the death, we're going to pursue the metaphor, but the battle is what they're doing, what they're engaged in. And sadly, sometimes it's very difficult for key reasons for the system to actually put limits around that. In a hospital, I might have people who come repeatedly to a hospital with multiple symptoms that they bring to the emergency department looking for help and care when actually the emergency department is not going to be able to provide it to them. So all our systems can come across people who fundamentally are there because on the basis of their own difficulties in functioning. So they're people with quite severe disturbances in their interpersonal functioning. So when we talk about things like conflict resolution, anger management, and try and enrol them in those sorts of programs, they're fairly good at A, not engaging with them, B, doing them in a superficial way, or C, which is more troubling, I guess, sabotaging them altogether. So we've all had repeat attendants at all these programs who might learn the language of the program but don't necessarily get any better when we meet them. And parenting is a prime example of that. I would see in my work people ordered to attend various parenting programs, which might be quite reasonable programs. It's not the fault of the program, it's the lack of fit between the person who's got a severe difficulty in personality and difficulties in their motivation with the particular program. So there are not many programs out there tailor-made for some of the difficult characters that we see. So personality disorder is a broad term, sometimes called severe personality disorder or borderline personality disorder. It's really referring to those ongoing difficulties where people have difficulties managing relationships, managing themselves, managing their moods, so affect dysregulation, people with poor impulse control, who frequently presenting around the place in situations of conflict and chronic, ongoing, maladaptive ways of behaving. Some of those people would end up in the mental health system, some would end up in the criminal system, some would end up within drug and alcohol services. I mean, it's frequently all of the above for people who are very disturbed. Their children are much more likely to be involved with child protection, often very early, and children are much more likely to experience multiple changes of carer. Now, the way to understand these people, I think, is to think about what we do know about the origins of these very severe personality dysfunctions and the issues we often struggle with in family work. That these are frequently people who themselves have experienced trauma, abuse, neglect. And what we are often confronted with, we might think of as reenactments or repetitions of really dysfunctional patterns. If they were abused as a child, these are the people who on occasion might abuse their child, sometimes in exactly the same way, seemingly without an emotional connection to that or understanding about how dreadful that is. Or they might be people who rationalise their behaviour with their child and say, well, I was brought up roughly, it didn't do me any harm. That's what's happening. It was okay for me, when glaringly obvious it wasn't. They have quite major difficulties. So they're people with their own unresolved traumatic histories. They're much more likely to repeat that. They have a whole range of difficult issues when it comes to parenting in a safe way. They can be anxious, sometimes in a positive sense, in an attempt to protect their child. They can be neglecting or even avoidant of their child. And we can understand that as a positive motivation, but it has a negative impact on child development. The child doesn't understand why the parent avoids them. But some of these parents can discuss that. The most extreme end, we see repetition. So we see this transgenerational patterns. Now, obviously, if we meet these people early enough, this is a real opportunity for doing preventive work. And that's where I think mental health services and parenting support services have a very important place if we're able to gather the resources to do that. But the idea of those sorts of programs would be to do that as early as possible. So some of the work I do with very, very severely disordered women would be in pregnancy. Now, these are usually women who have multiple risk factors, including substance abuse. They're usually in relationships of violence and exploitation, or they're trying to separate from those relationships. And I know that they're incredibly high risk when it comes to being a parent. Now, they might be highly motivated to parent. They might say, this child is going to be a positive relationship for me. I'm going to get it right. My child's going to have everything that I didn't. So often in terms of assessment, we need to try and understand the parent's insight into their own history and to see if it helps them think about the sort of parent they want to be, but also we need to evaluate the extent to which they understand their own risk. So that's where a good report, over and above telling you about the parent has this diagnosis and these symptoms, actually gives you much more information about how the parent's mental health issues and history of being parented and their own attachment history influences them as a parent and their capacity to prioritise and think about the emotional needs of the child. Now, I'm not meaning to be critical about reports, but sometimes my concern is that we're not necessarily, as report writers, giving enough clarity around those issues, which are the crucial ones as I see it, over and above arguments about diagnosis. So that often is important to clarify, but particularly when we're talking about this transgenerational issues. So the problems, as I've said, start early. I won't labour that, but obviously we're seeing inconsistent parenting, poor responses, sometimes quite frightening in the way that parents can relate to children, and parents who are sometimes overstimulating of children, wanting something, very needy parents wanting something from the child, and sometimes under-stimulating or neglecting. And it's that pattern of frightening, inconsistent behaviour that's important when we think about these sorts of issues. So this is what we call borderline disorder. And I mean, I won't go into the terminology about where the diagnosis come from. It's not a particularly helpful term. Some people argue that we should just get rid of the term altogether and talk about complex reactions to early trauma. Pretty much universally, these individuals who end up with this diagnosis have experienced the early trauma. In terms of their own histories, these are the people where care has failed. Not just one carer, but a system of care has failed. They can often explain that quite clearly and still be very angry as adults about that. Others seemingly have very little memories about what happened to them, which is an important thing to note as well. They may have experienced direct, frank abuse. It'll have a biological effect if they've been severely traumatised. And then what we see as these people, often young adults, who are in the process of becoming parents, is that they have around them repetition in terms of their relationships of these very dysfunctional patterns. So the mothers particularly that I would work with who are in violent relationships or dangerous relationships or situations of exploitation and emotional abuse have pretty much universally been experienced abuse themselves. And it's very, and I'm sure we'll hear about that, but it's always very difficult when we meet very young women who are in these situations. So I had a 15-year-old who I saw this week, earlier in the week, who I'd seen for the first time with a little baby who wasn't growing well, and she was struggling. She'd been in a relationship with a very violent ICE-affected individual who fortunately was in jail for issues related to drug offending. And she told me, I was asking her about that relationship and how on earth she felt that she ended up with him, what was it about him? And she was saying she wished it had worked out, but maybe he needed to go to jail for a while and maybe she'd take the baby to see him. And I asked her again, so you know, what were you getting out of that relationship? And she said, I don't really think I deserve anything different. That's what I get, that's what I deserve. So that terrible sense of, you know, having little self-worth, being deserving of abuse and humiliation. If you're seeing that in someone who's 15, and obviously that's really concerning. But that's sadly not uncommon in these sorts of situations. So I'll just say a couple of words and then obviously we'll finish. But thinking about these parents with these sorts of issues, what we should be doing as if we're doing mental health assessments and then providing information about is letting you know about the patterns that we see when these people are parenting. They can obviously be very depressed, so a diagnosis of depression as well as personality disorder is very common. That just tells us something about people's maybe despair about where they are, but also tells us that they might be inattentive or not have the energy to actually parent effectively. They can sometimes be what we call infantilising, meaning that they want the child to be there for them, and they like to keep the child a small child rather than allow a child to develop, because that relationship for them might be a hope of something positive. And there are various other patterns they can be rejecting. They're driven by unresolved trauma. But fundamentally, there is a risk inherent in these relationships of repetition and reenactment. And I think in terms of overall assessment of risk, that's going to be very important. The children, just to summarise it in a couple of sentences, and if you want to read more around these issues, there's an edition of the Medical Journal of Australia, which I published with colleagues in April 2012, a whole edition on parents with mental illness and the impact on children of all age ranges, which is a very accessible series of papers you could maybe look at. But essentially these are children and young people growing up with anxious and disorganised attachment, very anxious about who's there for them. We see the long-term effects of maltreatment and abuse, so a whole range of diagnoses, as I've said. We'll see behavioural problems, difficulties with aggression, regardless of what someone diagnosed them as, particularly children who've witnessed domestic violence or experienced physical abuse themselves. Both of those can lead to aggressive behaviour and dysregulated behaviour in the child. And we see ongoing difficulties with their own mood. So fundamentally what we see, and I think these are the factors just to, when we're thinking about evaluating the impacts on children, these are the factors that are underlying the poor outcome. We see interpersonal difficulties, ongoing difficulties in the child's personality development. So in many ways what we observe, sadly, in these situations of high risk are the impacts of the parent's mental illness on the child's developing personality and their own mental health. That's what we mean by the transgenerational transmission. So I hope that's given you a bit of a quick, somewhat rushed overview, and hopefully we'll have some time for questions at the end. Thank you very much.
Thank you, Louise. We'll have questions when we get to the panel. So now I'll call on Natasha to give us some insight from her perspective, well, from the police's perspective.
Okay. Well, thank you first of all for the Family Law Pathways Network and Francesca for putting on something like this and inviting place to it, because I think it's such an important space and such a difficult, complex space that we all work in. And Professor Newman, thank you so much for your insight. All those behaviours and character traits are the things that we see on the front line every single day and really find so difficult to manage and to deal with. So I'll just give you a little brief introduction. I'm a family violence advisor and I oversee family violence in this division, and we exist in this capacity. I sort of oversee a family violence unit that oversees police stations. So we're monitoring every single family violence report that's made to police to ensure that we're operating in the right capacity as police members and making the correct referrals and supporting families as best we can within the legislative framework with which we work. So in that capacity we work and operate under the Family Violence Protection Act and of course the Crimes Act and those sorts of things. But we also have a really strong role in Victoria Police in relation to the Mental Health Act and the provisions under that in relation to apprehending people who are exhibiting signs of mental illness and appear to be of imminent harm to themselves or another person. And obviously children often come under that banner, unfortunately. Basically, our role is to intervene in that situation, in that circumstance, remove that person from that environment, stopping any risk to harm for themselves. It's essentially almost like arresting a person and bringing them before a medical practitioner or a mental health specialist for assessment. My previous role was working in the Geelong Family Violence team, and in that capacity I ran a program alongside the Family Violence team which was called PACER, and that stands for Police and Clinicians Emergency Response, and they're essentially a secondary response service to people who are experiencing mental illness, suicide and self-harming. So at that level where police needed to intervene. And traditionally we would bring people into a hospital setting, so basically we would arrest them or apprehend them in the best way possible. More likely than not we were putting them into a police van and then moving them into the hospital system to sit and wait for a mental health clinician. So PACER evolved, and it was and some of you may very well know it quite well, it was a pilot that began at the Alfred Hospital and it's sort of moved out all over the place, and it's now statewide. We've got state funding, which is fantastic, but essentially it's a secondary response to people in that acute period in their life where they're experiencing suicide or self-harm, and we would take, police response would attend, so the frontline unit would attend, they'd make an assessment, yes, this person appeared to be having a mental illness or mental episode, and the PACER clinician with the police member would then attend as a secondary response and assess that person in their own home, which gave us the capacity to take into account all of the factors that are influencing that person, be it filthy, dirty conditions that they're living in, inability to look after themselves, children in the home, and all of those other factors that feed into that. So that, in the Geelong area and a number of other areas in Victoria Police now sits within a family violence space because those issues are so interlinked. So our role in relation to the Family Violence Protection Act is to attend and investigate any reported incident of family violence, irrespective of where that report comes from, and irrespective of how supportive the victim of family violence is in relation to that report. And then we have a series of options that we have, or criteria that we apply to that to determine what action we will take, be it criminal offences have occurred, so therefore we'll investigate and prosecute that. Do we need to take out an intervention order, and in what capacity does that occur, and what kind of referrals are required? Obviously assessing the needs of parents, mother and father, be it perpetrator or victim, and the needs of children, and appropriate referrals will be made in that space. So I guess what's important to sort of identify is that we as police are protective interveners in relation to children. So we have a mandatory duty to report to child protection where we get to that level, and obviously Child First or other small, lesser agencies where we deem that there's a need for intervention. In relation to how that feeds into the family law court space, to be perfectly frank, we don't have much involvement in that process at all. In fact, we're sort of trying to develop strategies whereby the police can get information from that family law court process so that we have a better understanding of what else is going on in this family's life, and that's, I guess, a bit of a work in progress, I think. So in every police jurisdiction these days we have family violence units set up, and as I said, part of their role is to oversee family violence reports coming in, but it's also about integrating services. So that happens in a number of ways, and it's obviously been going through the Royal Commission and things. We're trying to identify our best practice in this space, and we've made a number of recommendations to the Royal Commission in relation to how we see things going forward, as have multiple other agencies. So to some extent we're awaiting the outcomes of that Royal Commission to decide how we continue to function in this space, but essentially every unit that has a family violence unit also brings to the table the collective insight of child protection, women's domestic violence service workers, men's domestic violence service workers or men's referral services, police, often mental health services will come into it if we're aware that somebody has a mental health issue, and we will collectively assess the needs of that family. Corrections are another party that come to the table so that we can make an informed assessment, whole of picture really, in relation to our combined response to that family. And I'll just quickly give you a couple of case studies where that has occurred in my own personal experience quite successfully, and it will continue to evolve as things like RAMP, which you may or may not be aware, is a system of assessment where we deal with the needs of high-risk victims of family violence in a coordinated way. But myself, having that mental health portfolio locally in Geelong as well as a family violence portfolio, often came across women who were consistently women, who were experiencing a number of trauma factors. There was one woman I worked with who I commenced working with because of significant family violence with a very young child. She was referred to us from DHS, who are obviously assessing the needs of that child. And then over time that relationship disintegrated. There was a lot of drug use and the like. He was remanded in custody for the family violence offending, and she desperately wanted that relationship re-established, presumably because of the drug addictions and the links that he had to that world. So she commenced an absolute rampage of really crazy behaviour, lighting fires to her home, impacting other homes, running naked down the street, all that sort of thing, just to attract the attention of emergency services. I think, honestly, with the intention or the belief that she would then be placed in the cell next to him and they could reconnect. But over time that became really complex, and in actual fact she did impact the home of another person and was charged with really horrific, serious offences as a result of that. And so the strategy then became about protecting her once she came out of custody. So she was on remand for quite a significant period of time, but knowing first offence, never had any trouble with the law before, this sort of chaos entered her life. But again, real history of trauma with herself, history of sex assault, history of family violence, and obviously young child and all those pressures that go with that. So we collectively brought the fire department, DHS housing, child protection and everybody, corrections, to the table to say, before this young woman gets released from custody, how are we going to manage her life? How are we going to manage her reoffending? Because this is sort of the path that she set herself up for now. And mental health are at the table as well. And things that hadn't even occurred to me, like the CFAs, their knowledge around having a fire impenetrable home and that DHS housing could facilitate that, facilitate the type of heating services that she had, the fact that they could put, you know, things on her tap so she couldn't get too hot, so that the stove wouldn't get over a certain level of heat, but, you know, she didn't have a gas heater, and all those considerations that, you know, if we were just looking at this as an isolated case, we would never have considered. So I think that just highlights the way that interagency collaboration has to be the way that we move forward, so that some of these levels of trauma on individuals and their children and families can be better assessed, moving through both the criminal stream and obviously through the family law court and our civil processes in relation to interventions and the like. So I guess I'll finish up there. I think that I'm certainly coming in at a different level, I think, to others in the room and others that will speak, but I just wanted to highlight that, and I'm more than happy to answer any questions as the panel progresses.
Thank you very much, Natasha. I think you would see the benefit. She used some of my favourite words, interagency cooperation, and we're delighted to have Natasha and the Victoria Police now being represented as part of the Family Law Pathways Network. Look, just before I call on Judge Curtin, you've been sitting for a bit now. Please take a moment to go and grab something to drink if you would like, and have some fruit or one of those death-defying cakes that are up there. And that's mainly because I think Judge Curtin will do a beautiful closing of the loop for us and open the door to what I think is an interesting panel conversation. And I just hope that you can all get yourself a bit refreshed and stay right through to the end, because we mustn't miss this moment. Thank you. Just give them a moment, Judge. Surprisingly hard to hear the questions if you call them out. Thank you. Thank you, Judge Curtin.
Professor, sergeants, colleagues, experts. On Monday when I arrived in Chambers, I knew it was going to be a tough week. I was the duty judge. I had 75 cases to deal with in 3 days. And then later in the morning on Monday, Judge Burkhardt attended my chambers and said, "Ron, you know all about mental illness, don't you?" I didn't know how to take it. But he explained he was jammed today, so Judge Burkhardt sends his apologies and asked me to stand in his stead. Can I tell you, I think it's a tough brief. The Professor spoke in a very informative and helpful way. And I'm expected, according to this flyer, to talk about the implications of the issues raised by Professor Newman. I'll do my best. Can't make any promises. Now, for those who don't know me, just a bit of background. I undertook articles in 1976 with a private firm. I was admitted to practice on the 1st of April 1977. Note the 1st of April. I thought that was prophetic. I then worked as a lawyer for 6 years with legal aid. Initially with the Australian Legal Aid Office. I established the duty lawyer scheme in the family court. I was the first duty lawyer. I worked alone in that role for 3.5 years. And over that period I saw over 4,000 clients and appeared in hundreds of cases. The longest went for about 3.5 days. I was then called to the bar in 1984. Initially I did a bit of everything, crash and bash, crime, family law of course, children's court, which, to be honest, I found some of the most distressing cases. And I found about 1987 I became a specialist in family law. When I was at Legal Aid, I did my first separate representative case, they're now called ICLs, in 1978. And when I finished my years at the bar, I specialised as counsel for independent children's lawyer. This is my 4th year as a judge. It's very challenging, but it's great to be able to put something back. You bring some experience to this role, and it's important you try and use that experience to help others. Our court, the Federal Circuit Court of Australia, is what I call the engine room of family law in the federal sphere. We do 80% of all family law. The family court does the rest. We, as a major unstated aim, try to have litigants and their children leave the court in a better state than they arrived. That's in an emotional sense. Whether we achieve that, we're not too sure. But one of the biggest problems we have in achieving that is mental illness. The two most common allegations we come across in court are domestic violence and abuse, and the second one is mental illness. It's easily made and hard to really investigate and find answers to. As you know, the parenting capacity is our touchstone for Part 7 of the Family Law Act. And often you find in these cases there's serious impact on children. Often they're confused and troubled, or the role's reversed. You have a child that's taking on the role of a parent, like this little 6-year-old boy the professor talked about. And you have a dependent parent. And that is very troubling. It's very hard to deal with that style of relationship between a child and a parent. And I don't know that we have the orders that can overcome that style of problem, that can really cure the problem. You see neglected children, anxious children, children with physical risk, emotional risk. And then we have the other layer of children from other cultures, where you have language barriers and cultural barriers, but their mother or father has serious mental problems. And then you've got the role of the parent being disrupted by these mental problems. Now, my brief, the implications for the court. Well, the first thing we've got to decide is, are the allegations that are often made have any substance? And the difficulty for us is we first come across this no duty list where everything's an allegation. Nothing's proved till trial. But you've got to react in a way that's protective of children, promoting their welfare and ensuring that their best interests are never put at risk. So we've actually got to work out what is the mental illness. Now my experience is this is a term that is forever changing. What is a mental illness for one person is not mental illness for someone else. How you define it. And that's where we need to call on the experts to assist the court. We have to look at the nature of the mental illness. Is it short-term, long-term? Is it episodic? Or is it going to be there for some time? Is it only recent? Maybe it's not a mental illness. Maybe it's just the emotional reaction to litigation and separation and all of those things that cause people anxiety. Is it transition? Is it chronic? Is it severe? And the degree or lack of insight with the sufferer. Insight is a common problem in our court with the people who come before it. The lack of insight is common, traditional, and I look upon my role in some ways of trying to create that in people, to actually reflect on the problem they've got to deal with, and the other person they've got to deal with, the other parent or grandparent or whatever the case may be, and develop some sympathy for the role of the other person, to get some insight to what they're going through, and try and see cases through the eye of a 3-year-old child, or a 6-year-old child, or a 13-year-old teenager. It's amazing the number of people that come in and look at you in a very strange way when you raise this topic. But anyway, it's super difficult when this person has a mental illness, that layer of problem on top of that. So we turn to social science. We turn to psychologists, we turn to psychiatrists for initially to give us a report. And these reports are really just the start of dealing with this issue, because you can't take them at face value. And this is not a criticism of the profession, but the reality is, like lawyers, there's degrees of expertise. And you get some brilliant reports that are really helpful, and others that create more questions than answers. And that's where our system can have some strengths. You can get a great solicitor advocate or a good barrister that will analyse that report and then raise issues in terms of how it was created, the interviews, the questions asked, the style of the report, all of that goes to fulfil or fill in our vision what's going on in that child's life, what's going on in that parent's life. You then have, of course, family consultants. Section 11F, for those who don't know, is a brief report you can call on the duty list where A consultant attached to the court will quickly look at the issues, talk to the parties, sometimes the child, and come back with a brief report, 2 or 3 pages. They give you the bare bones of assistance about how you can deal with the problem in the interim, how you can establish some sort of outcome that's going to work for the child. They're great reports. It's really a great device that we've got in this registry and other registry. It works well. I think this registry is blessed with some very competent experts that do the best every day and have some challenges. They've got an enormous workload. And when the Section 11F comes into court and they give me a brief report, you see counsel itching to cross-examine the expert. My role is to protect them from that. My role is to say, thanks very much, that's a starting point, you can now leave, unless there's something to clarify. They've got to get on with their work, they do a hard job. And then, of course, we have the detailed family report. The detailed family report, again, is a roadmap to assist the court. Again, we can't take it at face value. You've got to analyse it, you've got to pull it apart. And the experts, when called to explain their position, I find do a very good job. It's rare that mistakes are made, but sometimes they do occur. Often these family reports lead to outcomes, good outcomes, in that the parties settle the case. Settlement's great for 2 reasons. The first thing is they've got control of their destiny, and that's really important. It's important they're feeling that they've put something into it, they've got an outcome they can live with. Secondly, the court can't function without settlements. The reality of the workload is so high that if every case ran, we would just stop. We just couldn't do it. Now, in terms of the other issues that we look to is the role of the ICL, the Independent Children's Lawyer. Often where there's allegations of mental illness, not only do we ask for reports, but where the children appear to be vulnerable, we'll make an order for a lawyer to represent the best interests of that child. And I've got to say again, in Victoria, we've got a specialist group that Victoria Legal Aid looks to and assesses, and to a person, those ladies and gentlemen do a great job. Because what they're paid in legal aid fees effectively makes their role pro bono. They're paid a pittance. And yet you get these very experienced, competent lawyers always putting their hand up saying, I'm prepared to be an ICL. I'm prepared to read all this, look into it, talk to teachers, talk to experts, and come to court and assist the court. Again, this is a great role of our profession that they undertake that's understated or unrecognised. And yet it's a great device for this court. When I was a barrister many years ago, I appeared in the Supreme Court in a de facto case, and the judge turned to me and said, Curtin, you know, one thing that your court, that is the family court, has over our court is the ability to call on the ICL to assist the court. And he was right. It's in this legislation, the Family Law Act, and it's one of the strong points of Part 7. It's a great device. It works for kids where the parent has mental illness, and it works for the parties as well. Because my experience with ICLs is they go out of their way to sit down with a person with mental illness and explain to them the nature of the problem, how the court operates and how it can help them move forward. And talks them into things like treatment or seeing experts. Because the other problem we've got is litigants in person. About 2 or 3 years ago, probably 2 years ago, Legal Aid changed their guidelines and stopped funding litigants for trials. They prepared them to, gave them aid to do their paperwork, and the paperwork was fine. But as soon as they came into court, they would get up and try and run something, and if they've got a mental illness or mental instability, it's hopeless. That is now being cured, I understand, and that Victoria Legal Aid's changed its guidelines. I hope so, because there's nothing worse than a person that's representing themselves with some sort of mental instability. Your ability to communicate with them as a judge is very limited because of their mental issue. It's even more so when they're in person. They don't understand the system, they're intimidated by it, they don't know how the system works. And yet they are trying to come along and run something that's basically impossible for them to be able to put their case properly. So hopefully Victoria Legal Aid will pick up that slack now. But that's another problem for the court with people with mental illness. We've just got to roll with the punches when they turn up and try and assist them when we can. My experience with that type of person is a 2-day trial turns into a 3-day trial, or a 3-day trial becomes a 4-day trial, because you've got to really educate them with each and every step. You've got to give them time, you've got to give them breaks. You've got to make sure the right witnesses are called if they're being treated. Then you want their treating GP or treating expert to be called. You have to arrange for that person to be called. Sometimes the judge has to issue a subpoena to get them there. So in many ways, when people are appearing for themselves with some sort of mental illness, you're running the case for them. But you can't be seen to be running the case for them. What you've got to be seen to do is get the relevant facts out into the arena. The options for judges, well, first of all, the obvious ones are supervision while someone's being treated, and then the question of treatment, whether it's medication, whether it's intensive therapy or some sort of general counselling. You can have conditional orders. For example, the person with a mental illness that's being treated, I've made conditional orders for that person to live with their own parents. In other words, the grandparents or some other adult figure that can effectively oversee them to ensure they take their medication, to ensure that they fulfil their roles as primary care of the child. I also do it because I want to protect them from further allegations. I don't want the other side, being the police person, seeing if there's other issues and then trying to bring the case back on an interim basis and complaining about that role of that parent. It's a bit like supervision. I sometimes order supervision so that there won't be further allegations about that person's incapacities or parenting weaknesses. The person that's supervised often gets very cranky with me, but I don't really care, because it protects the child and protects them from further allegations, and that's very important. There's other issues. Sometimes we've got to cease their role as a parent while they get treated. Sometimes we have to cease their role while they get assessed. And sometimes we have to cease it for good if this child is ever likely to be at risk, because we don't take risks. That's simply our clear brief. We have to assess, as the lawyers know, what is an unacceptable risk in these style of cases to the child. And sometimes you do form the view, sadly and reluctantly, that there is an unacceptable risk for that parent to be involved in that child's life. If it's mental illness, it's even sadder still, because in many ways the parents are victims of their own circumstances. However, if that's the case, that's the case, and you've got to accept that. You may only make orders in those circumstances for a parent to send presents or letters. There'll be no face-to-face contact. There'll be effectively no other relationship with that child. And if that occurs, then you've just got to make that order. Thankfully, I don't make them too often, but at the end of the day, that's one of the options available to us, no matter how unpleasant it is. The other option in running these cases is the appointment of a litigation guardian. We have the power where someone has some sort of mental illness and they can't give proper instructions to their lawyer to appoint a litigation guardian for them. That person comes along with the ill person and their lawyers and advises the lawyer what they think should occur. It's very hard to find very competent people to do that. Usually it's a relative or a friend, and little do they know they're walking into a furnace of trouble. So I admire them when they put their hand up. It is a very difficult role to be a litigation guardian, but again, it's a great device for us. So at the end of the day, where do we go? I'm not entirely sure, because mental illness seems to be a growing problem for society and the court. There seems to me a lack of resources. I know this is a common crime, and we do it. I know our court's grossly under-resourced. The police are grossly under-resourced. At the end of the day, it's a matter of priorities. But I really do think that society has forgotten those people in many ways that suffer mental illness. You only have to see the people sleeping rough and wonder how they got there, and whether in fact they're victims of their own mental illness, and what little we are doing for that. Anyway, I look forward to questions, and thank you for putting up with me.
Okay, so I think there ought to be lots of questions, and there's two people, Kaiki and Adam, are walking around with microphones. So please just say who you are and direct your question. Well, I'll get started. Oh, there's one. No.
Hello, I'm Sandra Thwaites, one of the court networkers in the Family Court. I just have a question for the panel. I was in a court one day when a young mother, obviously with anorexia nervosa, was in the witness stand and being questioned by the barrister from the other side. I've had some experience of a family member with anorexia nervosa. I have read a lot about it and been to seminars about it. And I just felt that was really very difficult, because I do realise that with that condition it does affect her brain, and I found it very, very, very confronting, because the barrister was asking her what happened over almost a 12-month period at times when she'd been visiting a psychiatrist, and I don't know how on earth you would remember anything like that, and it profoundly affected me. So I just like that question.
I guess I better speak this. I guess I'm the one that should answer that first. We've got to live with the system we've got. I don't believe it's a perfect system. I think it's a very good system. When I finished studying law at university, the very last day of a lecture, the lecturer turned to me and said, "Now you know the law, tell me what's wrong with it." You see a bit of what's wrong with it. The nature of our system allows people to test the evidence, and sometimes it may appear to be a bit over-strong, over-tough. I perceive it's my role to ensure that there's dignity in court. So in that circumstance, I'd be troubled about what the judge did. Secondly, I'd be troubled about what counsel for that person did. They've got their own lawyer. They should be getting up on their hind legs and saying, "This is outrageous, Your Honour. This is a very ill person in that witness box, and these questions are grossly unfair." Now, if the judge wasn't aware of that, the barrister should have said so. I try and protect people from the system as best I can, because I know it is corrosive to their relationships. I know it's not a good thing. And I tell them when they, usually, not always, but I should, when they come into my duty list, the sooner you get out of this court, the better. The sooner you resolve your problems, the better. Don't think you're going to get every answer you seek in this court. All we can do is come up with an outcome that we think's the right one. And then I say, why leave your problem to a stranger like me, the judge, to deal with it? Why don't you deal with it? They don't expect that, but that's the way it should be. So I try and make this system as sympathetic as it can, but at the end of the day, you've got the system that's there. But again, the judge and the advocates for the mother should really be doing something about that. We don't always get it right. And I'm one of the people that doesn't always get it right. All we can do is our best.
Just to add a few words to that, I mean, I think what you're describing from a psychological point of view is that sometimes the system allows what fundamentally can be very insensitive style. And we obviously worry about the impact on the person, you know, whatever their illness might be. I guess in my experience, some of the cases that I've done, which have been criminal matters really about women who've experienced child sexual abuse, who are giving testimony about childhood memories of abuse in the presence of alleged perpetrators, who are cross-examined often in a very what I saw as a ruthless way. But obviously there's an imperative to try and understand these are incredibly serious allegations and so on. But it's very confronting, I think. I've also been involved in cases where a victim, alleged victim, was a self-represented litigant. Often, you know, they're problematic, of course, who interviewed his own daughter, who alleged that he sexually abused her in childhood, and that went on for 24 hours until she collapsed, literally. I happened to be there as an expert witness, but you know, as the psychiatrist there, was asked to evaluate her capacity to keep going in that situation. Now, those are rare, fortunately, but it's I think it can be a ruthless system and very hard to watch. Yeah.
whilst the microphone's coming up to Walter, I have a question which kind of follows on from that. There are direct people involved in the court practices, but I wonder, would it potentially be helpful if the community agencies were somehow able to have a brief, or even the court networks have some additional resources that might enable some coaching for what might go on. A long time back, I think the family court did have some litigation preparation, and I mean emotional preparation. I don't necessarily mean the legal preparation. Do you think, Professor Newman, that might be helpful?
I think for some people that would be obviously, very helpful. I mean, people do need to know what to expect and how the process goes. For people, though, who are particularly mentally disturbed, that might not be sufficient. And I'm always interested in, what we could do in the process if it is being, and as Judge was saying, very important that someone intervenes and someone who's in charge there actually monitors that sort of situation, where it might be quite evident that the cross-examination or the questioning is distressing to someone. So we need both, I think.
My name's Walter, and I'm just in the role of a mediator or chairperson of legal aid. Often we're confronted with a situation where maybe we have a first conference where there's a mental illness being alleged, perhaps minimised by one party who says that it's a less severe illness than the other one would say, so that's quite common. And so what we would do is possibly organise an initial time of supervision with a relative or even a contact centre for a number of months, and maybe then come back to a second conference with a psychological report or something like that. One of the things that sort of troubles us, I suppose, sometimes is how safe is that for the child? Maybe 3 months later, 6 months later, they've got a good report from a contact centre, or there's been untroubled supervised contact. But of course the question will be, moving on from that, the parent with the mental illness, actually depression, possibly other kinds of illnesses, that they're saying, I'm ready to move on now. I don't need that supervision. And I've undertook taking treatment. And the other parent, of course, is still concerned and worried. And I'm just wondering about what are the sorts of things that we might look for, and perhaps Judge Jim has some views on this, about what we might look for if we're going to steer it down a certain path that's safe for children, but also allows them to develop a relationship with the other parent independently, if that's safe to do so.
Well, I think you qualified it, which is the issue, is if it's safe to do so. Often in these seemingly intractable conflict situations, where those sort of allegations and cross-allegations, it's very hard to get that sort of objectivity about how the child actually interacts with the both parties. How does the child, and I think we have to reevaluate this from the perspective of the child and their development and their psychological state. Sometimes that gets overlooked. We spend all our time seemingly listening to both parties and their accounts of what's going on, which are irreconcilable and seemingly, can't be really, we can't really understand that. Reports can be sometimes useful, sometimes not so useful, depending. The best evidence, I think, that we have in front of us is the child's behaviour, the child's attachment behaviour, and if a child's old enough, the actual words of that child around their relationship with their parents. I personally like to see reports that always look at observations of interactions between parents, carers and children that can actually comment on the quality of attachment. So what's actually happening in that relationship? How does the child interact with the parent? The emotional quality, not just what the parent or person does, but the emotional quality of that relationship. Sometimes children in their behaviour tell us a lot more than either of the adult parties. And I think that's where you need appropriately trained people to do that. So having people who are child psychologists or child psychiatrists with that observational expertise, sometimes in courts Some cases we might actually do assessments of attachment, so you can actually do a formalised way of assessing attachment. I would always, in some of these very difficult cases, want to have a look at that. So there's more detailed levels of assessment that can be done if it's seemingly very difficult to resolve. The mental illness issue, I think if people are making assertions or allegations about someone having a mental illness that presumably they're saying it impacts negatively on their parenting or they're damaging and so on, you need to really look at the quality of a psychiatric report that's done. That's when you get into the difficult territory, obviously, of trying to work out what the diagnosis actually is. And I think if one... probably shouldn't think this, but it's true. If one psychiatric report doesn't provide you with the specific questions that are put, and some of the art is in putting the questions very clearly to the psychiatrist, I think it's reasonable to either go back to that person or seek another opinion that provides greater clarity about what you actually need.
Just a quick follow-up question on that. It's often, I think, the experience of some of the people who we get the psych reports, but they're actually not that helpful.
Yes, look, I'm
about the impact on the parenting.
Exactly.
It actually then says, there was no dysregulation, there was no affect, the person dressed properly, and they're
superficial as opposed
to evidence of a psychiatric illness today. That kind of thing is not that helpful.
In which case, I think you go back to parenting capacity, the quality of attachment, and the parent's capacity to be empathic about the needs of the child.
Thank you.
My name is Catherine and I'm a family lawyer. My question is for the Professor. In relation to psychiatric assessments, I deal with a lot of cases where parents, one or both, need psychiatric assessments. One of the criticisms of psychiatric assessments is that they're done in quite a short time frame. So there's a 1 hour appointment, they get the documents and they prepare an assessment. And we, as lawyers, read that assessment and use that to assist our case or to make a decision. I guess the question that people often have is, how much can you rely upon an assessment of 1 hour in circumstances where they haven't viewed the parent with the child, and they make an assessment about parenting capacity? And also, secondly, how effective is one psychiatric assessment when you haven't assessed the other parent and got their side of the story from them as well?
I have a view on that, but it's my personal view, and as a child psychiatrist, I do not think it's adequate to give any judgment at all about parenting capacity without seeing the parent in interaction with the child and doing the sort of observational assessment I was describing. I personally wouldn't do that. I know I'm aware, obviously, that some people do, and they're doing them in very complex child protection matters, which I personally find concerning. A 1 hour appointment would be sufficient to do a symptomatic review of an individual, do a mental status examination and come up with, if you're an experienced psychiatrist, a differential is the person depressed? Do they have these symptoms? Have they had a history of these sorts of symptoms? But that's nothing to do with parenting. It's perfectly adequate for that. And you might have other documentation, obviously, in terms of history and so on. So it depends on the purpose of the assessment. But if you're saying that people are doing reports around parenting capacity on the basis of mental health without seeing the child or children involved, ideally we do the sorts of reports where we can see all the people who are involved with the children, because then you can have comparisons, obviously, in your observations, and sometimes we are able to do that. The cases I do, I guess I'm a bit selective, but I would do cases where that's what's wanted, because I think that's the adequate way of doing it. But I would be very cautious in your interpretation of reports if there's not observational evidence there.
And when you haven't assessed the other parent?
A good report might still be a very useful report, but if the other parent hasn't been assessed, the report needs to acknowledge that and to look at the various things that could follow from that, and just be aware of the limitations.
This is a question for Professor Newman. I'm Lauren, I'm one of the Registry of Family Consultants here. And my question is about particularly adolescents and the impact on adolescents and their personality development when they're exposed to
primary parent with either borderline or I see more narcissistic personality traits and personality disorder, and the impact or I suppose I would be interested in your comment on what is the impact and what is the vulnerable age at which you're wanting to protect children. I know obviously the younger the more vulnerable, but when we're thinking about children who are having an opinion, they're voting with their feet, they're starting to have strong views and possibly alignments with these parents. I'm wondering if you could comment on, is there an age at which they are more able to protect themselves, that their personality is perhaps more secure and developed?
Well, look, briefly, personality disorders are chronic conditions. They're part of the person. So if a child has a parent with a personality disorder and they're an adolescent, they're likely to have had that parent's personality disorder influencing them for a long period of time. But obviously children's emotional needs and psychological states vary. So in adolescence we frequently see presentations of young people with very disturbed personality disordered parents who are themselves struggling with their own issues, identity, trying to form relationships, and sadly some of those children have experienced the negative impact of their parents' personality disorder. They might have been maltreated, they might have experienced neglect, or a whole range of difficulties, so you still have to get that history of what's happened to them. Some of these young people are trying to protect themselves, as you're saying, in these sorts of situations. If we're lucky, they're better able to articulate what the difficulties are, but often they're very angry, quite distressed, they're more at risk of getting into substance misuse, bad behaviour, risk-taking, and so on, that whole cluster of difficulties. So that's a pretty common presentation. So sadly, sometimes we're seeing the young person themselves has emerging personality difficulties as a result of what they've been through. But they're a very important group to work with, and I guess mental health services are probably better equipped for currently, because there's been an increase in adolescent services to help stabilise some of that behaviour and help the young person separate a little bit from some of the family dysfunction if it's going on, and to be more self-protective. But so services like Origin, the youth mental health services, Headspace and so on are quite good for those sorts of young people if they're able to engage them.
I'm up here at the microphone so I can get another turn before any other question. But, Judge Curtin said that mental illness seems to be more and more prevalent, and I'm wondering, and I suppose this is for the panel, how much there overlay is between the mental illness, the alcohol and drug, those comorbidities that we hear so much about, and the constraints in seeing the whole picture when we have someone before the court, or be it at the police level when they're doing their assessment. Is the violent person, drug-induced psychotic state part of a longer-term mental illness? And how do the police find out whether there's perhaps family law matters in the way as well? So, Natasha, have you got some comments on that?
Being a good negotiator. I think that in relation to that sort of cohort of drug and alcohol, or drug and other, alcohol and other drugs and mental illness, there's certainly a strong correlation, and I think childhood trauma and those sorts of things are all interconnected, and a lot of our work, I couldn't put a percentage on it, but an awful lot of our work is all in relation to responding to that type of trauma, that level of trauma. And the complexities around that are huge for police because we don't understand it. We don't understand. We're still really trying to, certainly in the family violence space, help members to understand the psychology, if you like, behind family violence, and that's a really complex area because we see things so siloed and siphoned in every other aspect of policing. To ask questions in relation to those historical sort of impacts and factors is really challenging, just in order to educate members, let alone getting them to actually understand the implications of those risk factors. So we're doing a lot of work in relation to that at the moment, and have been for a long time. But it's sort of just a work in progress. And I guess our risk assessment is always about our own assessment of risk for ourselves, for our partner, for the community as we're attending these jobs. So that always has to come first. And really that's so difficult because those factors feed each other. And particularly with methamphetamine, it's a really difficult substance because people go from up here to down here in the blink of an eye. So, and getting, descriptions and their own level of understanding about what they've said and done and is really complex, particularly where you've got multiple users or and memory lapses and all that sort of thing. We just really have to continually ask the questions, bring in other services, and make it, every time we deal with somebody who's got a mental illness or uses drugs, uses weapons and that kind of thing, we're supposed to flag them. There's paperwork that goes in so that when next time we see that flag in the system. But again, it's quite onerous on members, and when they're going from job to job to job, they don't get the time to do the paperwork for job number 1, let alone job number 5. So that's, again, it's about getting better systems in place, and a lot of that comes down to funding, unfortunately, because our systems don't talk to each other. Our systems don't talk to other agency systems, and the family law court is exactly the same. So we can, where we determine that there is a high level of risk for a family violence victim, contact the family law court. We're aware of the fact that there are potentially orders, and we get those often from the parties that are reporting. But it's difficult.
Paul Van, I'm a Brexit and family report writer for over 20 years, and have been looking for legal aid as a chair for over 20 years in mediations and family law. But my question is to Judge Curtin. It's a question really about the threshold of when a judge decides enough is enough, this child cannot stay with this parent with a mental health problem, the child has to, and they're the primary caregiver, and has to be taken from them and placed either with the other parent or someone else. And I know that sounds more like a child protection issue, but it was many years ago, before the Federal Circuit Court was even thought of, and the family court existed. I was involved in a case as a family report writer where the judge made that decision, and it was a traumatic one involving a 7 or 8-year-old girl. And the judge's order was that I was to go to the primary school, went off to school with a lunch and a school uniform, sent off by a mum. I was to meet her at the school and take her to the nearest child protection office, and she was to be placed for 6 months with her father and a paternal grandmother, not to see her mother for 6 months, to cut the tie because the mother's behaviour was so disturbing. And it traumatised me, that case, and it ended up that this girl's now in her 20s, and the father's contacted me through some other means, and she's well adjusted and happy, but she had nightmares about me too for many years, this guy who took her away from her very disturbed mother. It's unusual, but I mean, it shows that the judge does have that power, and it's verging on the sort of protective power, child protection power, because I know the family law system is about how to keep both parents involved and how to maximise that contact without ensuring risk is too high. So I'm not sure what the question is. when you going, I mean, is it difficult, obviously, to reach a point where you say, you primary caregiver aren't going to do the primary caregiver anymore, when the other party wasn't even asking to be the primary caregiver?
We're finding we're getting a lot of cases that have been or should be in the children's court, more and more. So that we have to be broad-minded about how we deal with social issues rather than legal issues. If the child's at risk, it's easy to make that decision. It's easy to say that I'm going to make sure that this child is not injured psychologically, emotionally, physically or any other way. knowing that we've got a child that could become an adult, knowing that we've seen many damaged adults in our court that were children and abused. A lot of this mental problem does arise from childhood when they've been victims of sexual abuse. They're never the same, never the same. Even as adults, we can give them all the therapy and treatment in the world, but they're damaged, and it's a tragedy. So you don't want to repeat that tragedy. You agonise over it, and you look to every device you can possibly use, like appointing an ICL, like getting the treating doctors in, the GP as well as psychologists and family reports. And you give warnings. You say to people at the interim hearing, look, these are my concerns with your behaviour. Now, I want you to do something about it. What do you suggest as a solution to ensure your child's happy? So you direct it to that person. You direct it to the other side, because often they will give you a lot of criticism, and then you sort out what is valid criticism, what's not. And the ICL is a great tool where you're thinking of removing children from a parent or their role, or stopping their role as parents. The investigative skills of ICLs is impressive. Contacting school teachers. Schools are a great resource for information. And ICLs do that very well. I've had them subpoena headmasters, teachers, as well as get school reports. But it is a decision of last resort. In the meantime, you try and protect the child as much as possible and maintain a relationship. But at the end of the day, if it's the relationship with the child, then it's the relationship that's got to go.
I think we have time for about 2 more questions.
If I could just ask a question, my name is Randall Bradshaw. If I could ask both the judge and the professor. It seems to me, I work in private practice, one of the problems you have is if you need a psychiatric report, normally it's fairly obvious at the very start of the allegation being made, is the cost of the report, and also probably even more difficult is to find a psychiatrist who can do it very quickly. There appears to be a very limited number of psychiatrists, but obviously there's not a large profession. A lot of psychiatrists don't want to be involved in court cases, spending their time hanging around court, writing reports, being abused by both sides. It's something that, to me, has to be addressed, and I know the court doesn't have the funds to do it, but the system seems to break down that you might, when you go on the first occasion, have an order that a report be prepared, but if it's going to take you 6 months to find a psychiatrist who will do it, the parties be able to pay for it. Sometimes, at the moment, it could be up to $8,000 for a report, a psychiatric assessment of the 2 parties and a report. That's not uncommon. And then get a date to come back. 6 months up the track, the damage can often be done. I'm not sure what the judge thinks can be done. I see here today, I've been involved in this area for some 40 years, and there are a number of people who used to be called family consultants who worked when they were very young in the family court when it opened up. And in those days, you used to be able to virtually ring people in the court system, in the psychologists or the family consultants, say you have a case, they need to see someone quickly. In those days, within a couple of weeks, parties could be seen before he even went to court, and often a lot of these things could be resolved or the parties put in the right direction. Those days are well and truly gone, but as a result, it's so difficult to get anything done. It makes it very hard for children who are caught up in these very dysfunctional families, and believe me, there are a lot of them.
Do you want to go
So I don't
first or
know
me?
who responds to
Do you want me to go
that,
first?
but I think there is a funding issue and also the availability of people to do reports that you can rely on that can be done quickly.
Randall, if they come into the system already with a problem, then the first thing I turn to is their own treating GPs or psychologists or psychiatrists and get a report from them. You've got to be careful though, because often these people aren't as objective as they should be because they're treating that person. And you've got to analyse the report very carefully. I find that's a good starting point. I often order supervision at a contact centre and get a report back from the contact centre. They're also a great resource for judges. In terms of getting a quick psychiatric report, there's no such thing. We can order one. I've had waiting periods of 3 to 6 months. I have to call on Victoria Legal Aid to fund it. I have to do a strange thing. I can't do a consent order for one. It has to be an order of the court, otherwise legal aid won't fund it. But then again, that's fine. And I'm often calling on the ICL to use their funding to pay for a report. That's a good device if you have to. And most ICLs will use their funds for that purpose because it helps their role. But I don't know how to speed it up. There's more and more psychiatrists who are getting shy of coming to court. That's also another problem. Years ago we used to have quite a good number of psychiatrists. I think they're either all retiring or done so well they've gone bought yachts and enjoying the yachts rather than working. But whatever the reason, there's a limited number. You can count them on one hand that are happy to do psychiatric reports in our court. And that in turn means they're very busy and just leads to more delays. You've just got to protect the child in the interim period until you can get a report that you're comfortable with. And if that means supervised time with, well, so be it.
I have no answers. Look, I think you're quite right that there's not a pool of psychiatrists who are wanting to do this sort of work at the moment. I think the solution in the longer term is to help the young trainees, particularly. I work in the largely public sector and university work, but I think the young ones need to be desensitised, if you like, to court. They are fearful of court. They have panic attacks at the thought of cross-examination. So a couple of colleagues and I have a program where we're taking some of the young ones. They watch us do assessments. We help them learn how to write reports. They can come to court and watch us survive ruthless cross-examination. I think we have to have programs like that.
And I think just on this point, judges have got to protect these experts, right? There's got to be reasonable cross-examination, not cross-examination for the sake of it. And it's got to be an examination that assists the court, not because you've got an angry barrister. So we've got to be more alert to that. And don't hesitate if you're giving evidence to turn to the judge and say, look, I don't think that's a reasonable question. That's real hint to the judge to start doing something. And don't be fearful of that. I've got friends that are experts and they say to me, we don't want to come to court. We really don't want to do it. We get anxious about it. And I think, yeah, what's your problem? You've got a great judge there. They'll protect you.
Just before we ask this a last question, but do I see a possible role, Professor Newman, for Family Law Pathways Network? We're working with the young lawyers, the final year students, to try and familiarise them with the whole of the law system, and we're doing a great job, aren't we, Adam, with connecting these lawyers before they start their practice with the work that community agencies can do and private psychologists, etc. So maybe we look at a program where we work with you on some of the young emerging psychiatrists, and with Judge Curtin's support, we work on a program that does indeed make them more enthusiastic, because we've seen some great work coming out of the young lawyers that are emerging as a result of the work that is being done by our project officers. So we've got one last question. Thank you very much.
I'm sorry at this hour, I'm stepping in to be a family lawyer. This is partly an answer to Randall's question, but it's about psychiatrists, and it seems to me that in any parenting case where it's a very difficult one and the parents are very difficult, there's too big a propensity to order psychiatric reports, and I say that in the context of comments from Professor Newman and other sources that I've heard. But it's much more important to look at the relationship between, the direct relationship between the parent and the child, how the child responds to the parent, how the parent is actually hurting or otherwise the child, to see their mental health playing out in practice, rather than to just put a label on them. And I wonder, Professor Newman, could you comment on, well, perhaps, and Judge Curtin, the issue of, are we overusing psychiatric reports? Because I have a feeling we are.
You may be. I think the question, the more pertinent question is maybe to be absolutely clear. We all need to be clear about what is the purpose of the report. What are the questions that are being asked? Is it to clarify diagnosis? That might be a reasonable question in certain circumstances. Is it to have a qualified a psychiatrist with extra skills who can actually give you an idea about the interaction and do that level of observation? Is it about attachment relationships? Sometimes the questions are not really specified. You say, I want a psychiatric report, and really that doesn't tell us enough. So I think it needs that sort of clarity. You've got very, very well trained and skilled psychologists and people with observational training who can do a lot of the interactional assessment. You might not need a psychiatrist. So again, I think it depends on being clear about purpose and aims of a report.
In my court, I ask them the purpose of the reports. Often a psychologist will be a better tool to get an advice and outcome that will assist you more than a psychiatrist. If you're going to use a psychiatrist, there has to be serious allegations about mental illness rather than psychological aberrations or some sort of emotional disturbance. And usually a psychologist's report will sift it out better than a psychiatric report. But having said that, look, we're so busy, often people come in and say, we've just got consent orders for a psychiatric report. And I'm not in the position to say, well, why do you need this person? Often, my experience as a barrister, you get a psychiatric report to disabuse the other side of any psychiatric illness, but it doesn't really progress the case. If judges had more time to ask a few more questions, maybe there'd be fewer of them, I don't know.
I think that Manuela, who is definitely representative of the host, has something to say.
Thank you, Francesca. Just one final question, which is related to the two questions that have just been asked. Judge and Professor Newman, I wondered if you could comment on the place for a single expert report. I think Professor Newman has already mentioned the importance of doing an observation of the parent and the child before a psychiatrist can purposefully comment on the nature of parenting capacity. I don't think that's a culture that's alive and kicking in Victoria in terms of ordering or seeking single expert reports, but I do wonder whether you could comment on whether that is something that in specific situations where there are allegations that appear to have substance in relation to both parents' mental health and in relation to their parenting capacity, whether perhaps consideration could be given by the legal profession and ICLs in particular, but also the court to ordering a single expert report and therefore not necessarily consider a family report as well as a separate psychiatric assessment of parents.
Simple answer, yes, absolutely. I think in specified circumstances, it's much more useful to have the single expert who can give you that overview. It's usually the ones I do. It's usually very complex cases where there's been different levels of reporting done already, and it's actually very useful, I think, I hope, to the court to actually take that overview and to have another look at it in all its complexity and see all the parties. I mean, that's how I prefer to work. Some people might not, but I think it's very useful.
When you say single expert, do you mean to do a psychiatric assessment plus a style of family report? I find them useful, but I prefer really a thorough family report along with a separate psychological report about a parent or psychiatric assessment. I start with family reports by going to where the children are interviewed. I find that very interesting. I then go to the observation section and read that, and then I read the rest of the report. And that leads me to read those areas twice. They're the first things I look for. You get great information from young children or teenage children about the behaviour of parents. Really sensational stuff that nails their case. And you quickly come in, and I often do this in trials, and say, look, this is running. Clearly you haven't read the report. Little Johnny's been saying this about the changeovers that you complain so bitterly about, or some other aspect. And then I send them out to talk. I've seen single expert reports, and I've seen some very good ones, but I prefer as many reports as I can read, to be quite frank. And you can get different angles on issues whether you use more than one expert. You can get a different view on an outcome that may have not occurred to the parties or even the judge. the more reports that I've got, the merrier I am, I've got to say. The more experts can assist me, because I'm not an expert on these issues. I'm supposedly an expert on the law, and I'm not too sure about that sometimes. But you do need the experts to assist us to deal with young kids and all their emotional needs.
Thank you very much. Okay, folks, well, it was worth waiting for, and Professor Newman, it stirred up everything that we had hoped, and I do hope that we can have a further conversation about opportunities. We have a little acknowledgement gift. Thank you all for coming. That's it for this calendar year, but more exciting events and forums from the Family Law Pathways Network early next year. Thank you.